Hi friends, in this video we are going to deal with the article titled Criminal Procedure Identification Bill 2022, the key highlights. To know more about it, let's quickly move on to the topic.
Hi everybody, in today's session I will discuss about the Criminal Procedure Identification Bill 2022. So let's start with a very basic idea of what this bill was all about. The Criminal Procedure Identification Bill 2022 was introduced in Lok Sabha on 28th March 22 and has been passed by the Lok Sabha on 4th April 22. The bill has replaced the Identification of Prisoners Act 1920. Now let's take a brief on what this Identification of Prisoners Act 1920 was all about. The Identification of Prisoners Act 1920 allows police officers to collect certain identifiable information like fingerprints and footprints of the persons, including convicts and arrested persons. Also, a magistrate may order measurements or photographs of a person to be taken to aid the investigation of an offence. In case of acquittal or discharge of a person, all materials must be destroyed. There has always been advances in technology that allow other measurements to be used for criminal investigation. The DNA Technology Regulation Bill 2019, which is still pending in Lok Sabha, provides a framework for using DNA technology for this purpose. In 1980, a Law Commission of India, while examining the 1920 Act, noted the need to revise it in line with the modern trends in criminal investigation. In March 2003, the Expert Committee on Reforms of the Criminal Justice System, chaired by Dr. Justice V.S. Malimat, recommended amending the 1920 Act to empower the magistrate to authorize the collection of data such as blood samples for DNA, hair, saliva, or semen. Now let's go through some key features of this bill of 2022. So this bill expands, number 1, to the type of data that may be collected, number 2, the persons from whom such data may be collected, and number 3, the authority that may authorize such collection. It also provides for the data to be stored in a central database. Under both the 1920 Act and the 2022 bill, resistance or refusal to give data will be considered as an offence of obstructing a public servant from doing his duty. Now let's do a bit of comparison between the key provisions of both the of the 1920 Act and the 2022 bill. So the first differentiation is on the point of data permitted to be collected. Earlier, in the Act of 1920, fingerprints, foot impressions, photographs were permitted to be collected, but now in 2022 bill adds biological samples and their analysis, behavioral attributes including signatures, handwriting and examinations under section 53 and 53A of CRPC. Second difference is on the basis of persons whose data may be collected. So earlier in the Act of 1920, convicted or arrested for offences punishable with rigorous imprisonment of 1 year or more, such data may be collected from such persons. But in the bill of 2022, the persons who are convicted or arrested for any offence, the data may be collected from them. However, biological samples may be taken forcibly only from the persons arrested for offences against a woman or a child, or if the offence carries a minimum of 7 years of imprisonment. Earlier, persons they were ordered to give security for good behavior or maintaining peace. Now, by the bill of 2022, persons can be detained under any preventive detention law. Earlier, the magistrate may order in other cases collection from any arrested person to aid criminal investigation, but now in the bill of 2022, on the order of magistrate, data may be collected from any person, not just an arrested person, to aid the investigation. The third differentiation is on the basis of the person who may require or direct the collection of data. So earlier in the Act of 1920, investigating officer in charge of the police station or of a rank of sub-inspector or above collected the data. But now in the bill of 2022, officer in charge of a police station or of rank head constable or above, they can collect the data. In addition, a head warden of the prison may also require the collection of data. Earlier, the magistrate used to order collection of data, but now, after the Bill of 2022, the Metropolitan Magistrate or Judicial Magistrate of first class, they can also order the collection of data. In case of persons required to maintain good behavior or peace, the Executive Magistrate orders the collection of data. So here we end with the topic of this differentiation. Now let's see the issues to be considered. So there might be one issue, that is that this bill of 2022, it may violate the right to privacy under Article 14 of the Indian Constitution, as well as the right to equality. So this bill permits the collection of certain information about the individuals for the purpose of investigation of crime. This information forms the part of the personal data of individual and is protected under the right to privacy of individual. The Honorable Supreme Court has recognized right to privacy under Article 14 of the Constitution as a fundamental right. The Honorable Supreme Court has also laid down various principles that should govern any law that restricts the right, which includes public purpose, and that this is the least intrusive way to achieve the purpose. This means that the infringement of privacy must be necessary for and proportionate to that purpose. The bill may fail this test on several parameters. It may also fail Article 14 requirements to law to be fair and reasonable and for equality under the law. So this issue arises because of the following facts. Number one, because data can be collected from the convicted person, but also from the persons arrested for any offense and from any other person to aid the investigation. Number two, the collected data is stored in the central database, which can be accessed widely and not just in the case file. Thirdly, no relationship is needed between the data collected and the evidence needed for the case. There is no relationship between these two. Number fourth is, this data is stored for 75 years, which effectively means that the data is stored for life. Number fifth is, the safeguard have been diluted by lowering the level of the official authorized to collect the data. Now let's discuss an example which will help you to understand the provisions of this bill in an effective way. So suppose a person X is found guilty in the case of rash and negligent driving and he is punished with the fine of ₹2,000. Then the data collection authority may have his signature collected and stored in the central database for 75 years. This bill, the bill of 2022, this bill permits this storing of data. Now let's take one more example. Suppose a person A is arrested and the case goes on for a period of 20 years through several appellate levels, which is quite unusual. His records will remain in the database for this period. If he gets acquitted and is arrested in another case just before the final acquittal in the first case, the records can be kept in the database until the second case is decided. This process can be continued through a third case and so on, like it goes on until the person is finally acquitted. So I hope you find this helpful, and thank you.